Thank you. Let me start off as the Executive Director of the Illinois Liquor Control Commission. I want to personally thank our esteemed panelists, all of our licensees, our participating ILCC staff members, as well as attendees and guests attending today's Liquor Industry Talk. The Illinois Liquor Control Commission is a state regulatory agency. We regulate the manufacture, distribution, and sale of alcoholic liquor in the state of Illinois. We do this under the regulatory framework of the Liquor Control Act under the direction of a 7-member commission. So what does the ILCC do? We process new and renewal applications and issue licenses. We impose fees as well as suspend and/or revoke licenses for licensees that violate the Liquor Control Act. We adopt rules and regulations, conduct premise inspections. We receive and investigate illegal and unlicensed activity and complaints which allege violations. We conduct underage compliance details, hear and determine local municipality appeals, as well as develop industry educational programming, which is, related to responsible alcohol serving and selling, as well as the illegal underage purchasing and consumption of alcoholic beverages. These things and a lot more are handled under the ILCC's licensing, legal, and industry education and enforcement divisions. We at the ILCC understand that the liquor industry consists of complex and often confusing myriad of laws. As such, we do welcome inquiries either in person or via email or via telephone. We want to be a resource to our licensees to minimize unlicensed activity and violations, which is why we routinely conduct trainings, publish webinars such as this one, as well as a quarterly newsletter, in which our goal is to provide useful tips and information for the industry. Thank you again for the opportunity to present today's Liquor Industry Talk, where I am joined by ILCC staff members, Nicole Sanders, Deshanka Marion, George Martinez, Rick Haymaker, as well as local liquor commissioner, Mayor Bernard Alsbury, and retail licensee Norman Bolden. And with that, I'll turn it over to them to introduce themselves. Thank you again.
We'll start with Mayor Alsbury.
Hello, I'm Mayor Alsbury of the Village of Hazelcrest, mayor for the last 12 years. Hazelcrest has a variety of different liquor licenses from A to I, I'm sorry, like from A to J. And so being the liquor commissioner, all licenses come through me with the consent of the board. Thank you for having me today.
Thank you for joining us. Next, we'll start with Norman Bolden.
Hi, I'm Norman Bolden, CEO of Norfolk Holding Corporation, of which entities include Norman's Bistro, Haven Entertainment Center, Room 43, and Norman's on the Lake at Rainbow Beach.
Thank you. And then I'll go ahead and start with ILCC. So Deshanka.
Good afternoon, everyone. My name is Deshanka Marian, and I'm the licensing administrator for the State of Illinois Liquor Control Commission. Myself and my licensing team are responsible for reviewing and processing liquor licenses for all 3 tiers, which is our manufacturing supplier tier, our distribution tier, and our retail tier. I want to thank all the attendees for joining us today on behalf of the licensing division and look forward to answering any questions or concerns that you may have. Thank you.
All right, next we have Richard Haymaker, who is our legal counsel.
Hello, everybody. Rick Haymaker, legal counsel, one of 3 legal counsels for the commission. Together with me that comprise the legal division is General Counsel Noel Kwanbeck and legal counsel Avi Zisuk. Together we handle various legal issues that come before the commission, some of which are a continuation of the enforcement division matters, and some of which are not, that we'll get into later in the presentation, but good to be here.
All right, and then we also have our enforcement supervisor, George Martinez.
Hello, everyone. My name is George Martinez, as Nicole mentioned. I am the Chicago North Region Supervisor. I cover mostly northern Cook County, Lake County, and a portion of DuPage. I have probably 3 agents that work in my region, and we're still building our team. And thank you for inviting me on the panel.
All right. And as was mentioned, my name is Nicole Sanders. I'm the Industry Education Manager here, and I will be moderating today. So how this will go is we have a presentation that we will present to you, and there are questions that were pre-submitted. So in the interest of time, we will ask questions during the breaks of the presentation, and then if we have time at the end, we will ask additional questions, okay? And to get started, we will go ahead and start with the presentation. And Curtis Franklin, our legislative liaison, will be controlling the presentation today. So we'll start with licensing.
Good afternoon, everyone. So it all starts with the licensing process. In a quick overview, the licensing division is responsible for reviewing state liquor license applications. On a monthly basis, we issue about 200 new liquor licenses, and we renew approximately 2,000 liquor licenses on a monthly basis. We have 60 different licensing categories, which can include airplanes, trains, liquor stores, winery shippers, out-of-state distributors, special events, non-resident dealers, which are suppliers of alcohol, national and foreign licensing, and brand registrations. Any product that is sold in the state of Illinois has to be registered. All varieties, brands have to be registered with the Illinois Liquor Control Commission. We have staff in Chicago and in Springfield. Currently, we have 7 licensing assistants that review and process liquor license applications for the state of Illinois Liquor Control Commission. And next, we're going to go over the application process. In order to obtain a liquor license, you must complete an application and submit it to us here at the State of Illinois Liquor Control Commission. Also, renewals. You can renew your liquor license electronically. We have step-by-step instructions available on our website on how to renew your liquor license via your MyTax Illinois account. I'm happy to report we have over 97% of our licensees renew electronically. We also have the option for our new retailers. Those are bars, restaurants, hotels, packaged goods stores. They have the ability to apply for a new liquor license via their MyTax Illinois account as well. And some of the prerequisites that I'll go over quickly is, most importantly, local liquor license. If you're selling liquor at retail, you must have local approval. Illinois is a dual license state, which means the local jurisdiction, the local municipality, they have jurisdiction on the issuance of a local liquor license first. So you must obtain that local liquor license first. We will also require a copy of your certificate of insurance, along with a copy of your deed or lease. We need to see proof that the applicant has rights to the property in the form of a deed or lease. And in some cases, if you're buying an existing business or any personal property from the prior owner, we will require a copy of the bill of sale. So what are some examples that we can go over in reference to when and if a liquor license is denied? So one of the general review and processing times are 2 to 10 business days. So if you're applying for a new liquor license, it can take 2 to 10 business days for review and processing. And that can range, that's also the same range for renewals as well. We try to get the renewals done as soon as possible, but definitely new liquor licenses are 2 to 10 business days. And what are some of the common reasons for denials? And one of them definitely is missing information. You may have not completed all the required fields. You may have not left some information, a signature may have not been attached, or the questions weren't all answered. Those are just some examples. But with the new with the new applications available online, these fields are required. So the inability for you to, submit this application is very high if you don't fill out the required fields. Also, if the licensee is not qualified, an example of that is they may be, we run a name check and they may be tied to a license. They may have common ownership in one of the other tiers, a distribution tier possibly of licensure. So that's an example of a licensee not qualified. You failed to include required documentation. You failed to include a copy of your bill of sale, for example. And a very common one is tax issues. If there's any tax holds on your account or on any of the officer's owners, that is a reason for denial. Once a license is denied, we will issue you a correspondence and we give you an opportunity to address the matter. So you will have the option, you'll have something in writing clarifying what the issue is, and you'll have the option to resubmit. If a license is approved, you'll have the ability to print your liquor license from your MyTax Illinois account, and we provide step-by-step instructions on how to do that as well. Special events. State of Illinois can issue over 4,000 special events on an annual basis. And a common question we get is, when is a special event required and when is a special event not required? And really, you have to take a look at the definition of a private party, which is an event where attendance is by invitation only. The host controls access to the premises and alcoholic beverages are provided to invited guests at no charge. A special event liquor license is not required for a private party. So this is an example of when a special event license is required. Secondly is, what do you need? As a special event licensee, who can we issue this license to? You have to be registered with the Illinois Secretary of State as a not-for-profit organization. A special event not-for-profit liquor license is issued to a registered entity. So you need to make sure that you're registered with the Illinois Secretary of State as a non-for-profit. We do check that. And once again, Illinois is a dual license state, so local approval is required for special events as well. So the local municipality must approve the special event, and we require a certificate of insurance as well. And we also provide step-by-step instructions. This is an example of some information we have on our website with some contact information. We really are encouraging our licensees to apply online for their special event license. It really helps us expedite the review and processing of the request, especially for some of these that we receive last minute. So we do have this information available on our website. If you're having any issues trying to apply or need to contact the Illinois Department of Revenue to register, this information is available on our website. So an example of a license certificate, this is what our liquor licenses look like. We have a QR code on the license certificate as well. And this is just an example of what a State of Illinois liquor license certificate will look like once it is issued. As I mentioned earlier, we have online licensing resources available. We have a license lookup feature. We also have step-by-step instructions on how to print a liquor license, how to renew your liquor license online, how to apply for a new liquor license. We try to provide as many resources as we can for our applicants so they can apply electronically. We also have daily reports for the industry as well as local municipalities. You can verify licensing information via our license lookup, and this is all under the licensing section on our website. And that concludes the licensing division portion. I will be available to answer any questions, and thank you very much for your time today.
Okay, sounds good. Thank you, Deshanka. Now, I do have a few questions that were submitted. Sure. And I'll ask you as well as Mayor Alsbury these questions. The first one would be, and this is for Mayor Alsbury, what type of liquor licenses are available in your township?
Well, we have 12 different type of licenses, from special event licenses, license for alcohol on premises, alcohol for outdoor parties. We also have special licenses for hospitals. So it's a variety of different licenses. Again, we have 12 different types. So
Okay.
it's based on what type of event you want to do. We have a hospital in Hazel Crest, so we have a hospital license for when the hospital has events within their facility. So it's according with what kind of, if you have a club or if you have just an event, and you apply for that particular license. And they classify by different letters from A to J, A to L. Make sure I say that right, 12 of them. Yeah, A to L.
Okay. And my next question is, and this is for both the state and the local level, what are some of the required documents for your township? And then Deshaka, I'm going to ask you the same question. So, Mayor.
You have to have definitely have to have a background check. We fill out the application, and then you submit the name that we do a background check on before we provide your license. That can take from about a week.
And on the state level, just to circle back, we will require a license from the local jurisdiction. That is a requirement at time of application. It's for all new 1A retailer applications, as well as our renewals. We do ask for a copy of the local liquor license every time you renew your license. And if applicable, if you sell for on-premise consumption, or if you have a combined license, we do require a certificate of insurance as well. Also, if you're making any changes to the ownership structure, any officers or owners, we will require supporting documentation for that as well, which is also local approval, evidence of the transfer, and you need to make sure you update your tax information with the Illinois Department of Revenue as well.
Thank you. Thank you very much. What we're going to do is roll into compliance right now, and we'll ask a few more questions at the end. So I'll get started with George. Take it away.
Okay, I just had unmute there for a second. If you have any questions, or if we're going through slides, maybe we can go through the slides and I can explain them. So this slide here is our inspection checklist. So there are a variety of potential violations that are listed on this checklist, which can be found on our website. And the good thing for a retailer to do is to go through these, and if you have questions, obviously ask them, and but go through them. You might be familiar as a retailer with some of these. You might have even been cited for some of them. Most of them are preventable, if not all. And these go from a simple not having a sign to a ownership issue. So that's all I have on the inspection checklist. Okay, so here, exterior violations may consist of impermissible signage or DBA inconsistencies. An example of this is if we walk up to Joe's Bar and then we have a sign that says Jill's Bar. Now, sometimes our licensees think that that's a simple item, but we need to be able to determine what location we're at, and it has to be consistent with what's on our license. So that's an exterior violation that we will find sometimes. Yeah. Or a big one is the ILCC license is not valid. So your license with the local municipality may not be congruent with the time that the Illinois liquor license expires. So you may have an expiration date of April for your local license and one for December for the Illinois liquor license. They both have to be valid at the same time in order for the business to operate. That's the Illinois law. So check and make sure that your license is valid at the time that you renew your local license, and vice versa with the local. So sometimes people forget, retailers forget, and then we show up maybe a week after it expires, and coincidentally, and that would lead to a violation. So if you're selling during that period of time that you were invalid, the license has to be framed. So it says it on the license itself. That license has to be in a frame and in view of the general public. So it can't be in a book. I mean, you can have it in a book, but you need to have it also posted and listed, so this way everyone can see, any of your customers can see. Same thing with the local liquor license, except we don't require for that liquor license to be in a frame. That would depend on the local municipalities. So we just need for you to have it available there for us to see, to make sure that it is current. There's something called an IBT certificate. It's an Illinois sales tax certificate. Every retailer has one. It has to be available for us to view. It can be a copy, but we have to be able to view it, and it has to be current. It has to be, I think there are 5-year expiration dates on it. So you need to be on top of that to make sure that you are able to have a current one at the time that you're operating. Change of ownership also. Management has not been reported within 30 days. So this is, usually you begin this with your local municipality. You have a change in ownership for whatever reason, you report that to your local municipality. And then within 30 days of that change, you're required to notify us, the Illinois Liquor Commission. There's things called hidden ownership, subterfuge operations. Sometimes people operate under someone else's license, or the name of the license is in someone else's name other than the owner that's presented. And so that is illegal, and that's an egregious violation. So we will look into that, and we will find out if that's the case. And if that is the case, we will also share that information with our local partners. Pregnancy warning sign is not displayed. That's another simple violation that could be prevented. We provide those signs to you. So if we show up and we have a sign, we will give it to you. If you want a sign and you don't have it, you can download it on the Illinois Liquor Control website, and it'll be black and white, but that's fine. You can still use that. Human trafficking public notice is not posted. It's another one that's easily preventable. You can print these things off online and then post them in your business where they're supposed to be posted. Employees are not BASSET certified. This is a huge one. So you got to make sure that your employees within 120 days of hire, that they are BASSET certified. Sometimes the local municipality will require you to have that prior to operating, or as soon as you are operating, and have your people certified, but sometimes they don't. So it is the responsibility of the business owner, when you have on-premise consumption, that you have a person that's BASSET certified that's serving that alcohol. And SOS Corporation, the Secretary of State Corporation status is not current. So a lot of times the annual report will become due. Retailers will forget, oh, my accountant was supposed to do that, and they didn't do it. And so that could be a simple fix, but it can lead to a violation. So you make sure that you're on top of that all the time. Records violation, pre-mix receptacle cleaning records is not available. So whenever you have a pre-mix, you have to make sure that you date it. There are certain requirements that you need to comply with. The date, what product is in there, what the mixture was. And then this is the only way we can tell when that mixture was completed, because you have 7 days from that point to utilize it. Use it or lose it. Tap cleaning record is not available. Sometimes with the bars that have, or anyone that has a tap dispensary for either pre-mixed drinks or beer, they have to be cleaned every 2 weeks. And so you have to make sure that these taps either are labeled that they're being cleaned with a record or log, or you have to make sure that you keep the receipts to show that they've been done, and they have to be consistent every 2 weeks. As a retailer, or as a retailer, you can clean your own taps. You just have to show what you cleaned it with, the solution, and you have to keep the same records that that you would have if you had someone else, a company, cleaning them. Books and records not available. So books and records have to be on premise for 90 days. from the time that we inspect. So no one knows when we're going to show up because they're random inspections. So you have to keep that there every preceding 90 days every day. So what some retailers do is they purchase a 90-day waiver. And so that can be purchased for $10. And that is a one-time fee for this waiver. And what it does, it allows you to store your records at another location. You're still required to keep them, but you just don't have to keep them at that location. So if we need anything, we will send you a formal letter and request those documents. So that is available if you wish to do so. Infusion container record is not available. So same thing with the premixes. You have to make sure that whenever you're preparing a concoction, that these things, if you're going to store it somewhere, that they follow the proper premix or infusion contain laws. And so drink prices schedule is not available. Usually this is pretty good with most on-premise retailers, but you got to have a list of what your drinks are. You can't just come up with prices. So either whether it's advertised through happy hour or it's a point of sale, it's in the point of sale system. The consumer has to be able to see that, and it has to be available when they ask. So that's the inspection process. Here's part 4 and 5, sanitation violations. So sanitation violation is on licensed premises. So what I see a lot of is that there's mold in refrigerators and things like that, or you go to a refrigerator, even for off-premise location, a liquor store, you'll find a lot of glass, maybe that's broken, that's not cleaned up. These things are sanitation issues, and they will be noted, and they can be minor or major. And so it can lead to a violation. Contaminated liquor bottles. So if you have any deleterious materials in your liquor bottles, and that big word means that do you have anything that's not supposed to be in there? And most likely like fruit flies or bugs or insects or glass, plastic, cork. These things, you need to make sure when you're serving the general public that these things are not present inside that bottle. So this may require a daily check of your bottles. Some places have over 100 bottles. We have to check it when we go there. So it's just a precaution for you to do something like that, or to have some kind of contingency in place to check that, to make sure you're not serving alcohol with unwanted items inside the alcohol. Unsanitary taps. Sometimes your tap guys don't clean very well, so they will leave the taps dirty, or they don't do a proper job. And so we go there, we check it, and the taps may contain mold, or they may contain things that you don't want to be serving customers, and that customers probably don't want to be drinking. So make sure that you check your own taps too after it's cleaned. And the easy way to do it is either a Q-tip up the spout and run it through there. And if it comes out clean, you're probably got clean taps, but don't always rely on that. Make sure that these things are done, and that you're checking your serving with regard to that sanitation. Marrying liquors. So it's illegal to marry liquors, and what that means is that you cannot pour from one bottle into another bottle, whether it be the same brand or whether it be a different brand. This is not allowable. There's a law that requires that your filling of bottles only, or the filling of bottles only, to be done by the manufacturer of that product. So if you're doing that, then you need to cease, because this is an easy way for you to maintain liquor, from one bottle to another, but it is a sanitation issue. So make sure that you don't do that, or don't let your bartenders follow that kind of practice. Infusion not destroyed as required. So infusions can be, you can infuse a liquor or spirit for 21 days, and then you have another 15 or 14 days to be able to then sell that product. After the 35th day, you have to get rid of it. So same thing like the premix, use it or lose it, but there are specific requirements for that and for premixes. They are not the same. This information can also be found on our website, anything I'm talking about here. Interior violations, access to areas within licensed premises. You may have an office that you don't want your employees to go in for whatever reason, and you restrict access to them. But when we show up, we need to have access to that. So have a contingency for whatever license area you want to close or not have access to, so that when we show up there, you can provide us access to that. I'm not going to provide examples, but that if that situation exists with your particular business, you have to figure out how to be able to allow us to inspect on the premises when we show up. Same thing with access to liquor storage. If we don't have access to it, we cannot complete the inspection. So then it would be a failed or refused inspection because we cannot complete it. Brands and taps match. So if you have a tap that has a brand on it, that brand has to be tied to that tap. If you have a sign that says you sell Ham's beer, not that I promote Ham's beer, but that's comes to my head. If you have that, then you have to sell that. So you have to make sure that the brands that you have are available for you to sell. And if you don't, then put up a sign or somehow make that note available to customers or consumers that are coming in. I skipped a little bit there. Infusions need to be labeled properly. So you need to put whatever the spirit is and what's it infused with and the dates. And so these things need to can be in a log or it can be on the actual container. So those things, and when it was cleaned and et cetera. So make sure that you do that. Tap visibility. Some people don't label their taps. They just have like let's say, for example, a piece of wood and it's not labeled. And so you know what it is because you're pouring from your side and you can see it, but the customer needs to be able to see that within 10 feet. So if they can't see it within 10 feet, then that would be a violation. So let's skip over the advertised brands. Impermissible inside signage. So this is a tricky one. So impermissible inside signage usually refers to premise specific. So if you have come get Coors Light, and like I said, I'm not advertising any, it's in my head. Come get Coors Light at Joe's Bar on a sign, and you affix that to the wall permanently, then that is an issue. That is a signage issue. So there are a lot of nuances with signage, and that is in the Liquor Control Act 6.6, I believe. So if you have questions about what signage you are permitted to have, either review that or you can send an email to the ILCC enforcement mailbox. Properly licensed to sell tobacco. Well, you got to have a cigarette tax certificate or cigarette certificate in order to be able to sell tobacco. We will be checking that. If you have it and it's current, you're fine. If you have it and it's not current and you're selling tobacco, that can be an issue. That can be a violation. And coin-operated amusement devices. We call those COADs. So every year they get renewed by the Department of Revenue. So usually most retailers have someone within the vending machine or game items, and it's not legal game. It's not gaming like gambling. This is games for amusement devices like a pool table, something like that. Those things you got to make sure that those tags are updated every year, and that they're when that renewal comes around, that they are placed on the machine, or at least that you have them. Sometimes, we get, and I think that they renew July 1st or something like that. And if we get there, then and you don't have it, at least if you have it present, you can show us. Prohibited practice, violations of happy hour law. So that is in 6.5, I believe, or 6.5. 628 of the act. And so there's a lot of different things that that can be violated. Usually the things are advertising free. Most times, you get a free drink with this, you can't do that. So advertising violations are one of those, or you 2 for 1, or if you have you go over the allotted hours. So those violations are usually very common. Drinking games contests. So short answer is no. You shouldn't be having drinking games or contests that include drinks. That's violation. conducting a tasting in violation of product sampling laws. So that is, there is a rule on that. And if you want to conduct the tasting, it has to be done at a licensed location. And there are certain requirements for that. So the 100.500 rule will have that within it. Giving away alcohol, just bottom line, you can't give away alcohol. It's not, you can't do it at any time. Using unlabeled liquor. So if we don't know what it is, we don't know where it came from, neither does anyone else that's looking at it from our end. So it's illegal. You can't do that. Illegal transfer of product. So if you want to transfer product, you can't do it unless you have specific requirements. And one of those are that has to be common ownership, and you have certain percentages that you can transfer. And you have to make sure that you notice the distributor of that product that you're transferring and have approval from the ILCC. That's the short answer on that. Liquor purchase retail. So it's illegal to buy from another retailer. So for any reason, if you are a retailer, you have to go through the distributor. That's what the laws are set up for. Illegal importation. This is a serious violation. You cannot illegally import product. So this is can lead to regulatory and criminal violations. So purchases with invalid license. Once again, if you don't know your license is expired, then if you do purchase with that, if you somehow you manage to purchase with that invalid license, then it is a violation and you will receive that violation. If you are delinquent, and there's many reasons why retailers go delinquent, but you cannot, you or your commonly owned businesses that sell alcohol cannot purchase alcohol from a distributor or from anywhere. So you can purchase beer because that's cash on payment when it's delivered. But other spirits and wine cannot be purchased until you're clear from the delinquency list. And that includes you or any of your commonly owned businesses. Purchases outside designated territory. So this is more for a distributor violation. So this is if they go and I'm sorry, purchases outside designated territory. Oh, no, this is if you go somewhere and you purchase product that you bring to your location that's from outside the territory. There's a couple of things wrong with that. One is that you might not be entitled to get that. You may have to go to your distributor to get it. Example is if you go to Restaurant Depot, which there's two locations, one on Division and one in Lombard, that actually sell you alcohol. The distributor there is Midway Wholesalers. And you purchase something that you shouldn't be able to, but if you do and you're found out to purchase that, something that you should be going to your distributor in your territory, then you will probably hit for a violation with that. Don't see a lot of that. So warehousing liquor off premises, wherever your liquor, your license address is, that's where the liquor needs to be. Nowhere else. It has to be at that address. You can't put it anywhere else. Receiving items of value. These are violations that you may receive something for free from a distributor or a supplier. These things are prohibited, and they can range from tickets to providing them extra time to pay, or getting provided extra time to pay for a bill. So there's a whole large array of things that this could include. Illegal gambling, not allowed. So you have to have a license for that. And then violations of local, state, and federal ordinances, law violations. So these are things that we normally leave to the locals if it's a local violation, but it may include violations either here or in another state that received what we would call a conviction. So failure to maintain liquor liability insurance. Got to be insured all the time, and it can't lapse. That's all I have on that. Is there another slide? Okay. Statistical information. So we, as inspectors, go out and we look for statistical information to report back. Tobacco products sold, gaming, if it's a gaming establishment, how many coin operated, if it's a location that has coin operated amusement devices, if liquor is their primary business, gaming, adult entertainment, authorized occupants. So we collect that information, and that is stored in our database for several purposes. So our inspection reports are entered electronically, and so it may take some time from when we are at the business to enter that information. A day or two, shouldn't take too long. So once that information is entered, then usually that goes through a process of getting approved and closed. And then that may start the process of an offer and compromise, or just to show that you have actually have no violations. If it's offer and compromise, that means that you would have a violation, and then that violation will be processed through whatever requirement it is for that particular violation for you to receive. Investigative reports are typed, and evidence is attached to case. And once the cases are submitted for review, then the supervisor will approve it or make corrections or send it back for correction. And so that may take also a little bit more time. This also includes licensing inspections, pre-licensing inspections for locations of like distributorships, manufacturers. And so that may take also a little bit more time. Is that it? Are you done with my slides?
Yes, you are. Thank you so much, George, for all the
Yeah.
information.
Sure. Hopefully I didn't talk too much or too fast. So
I think you're
anybody
okay.
have
Thank you
questions
so much.
or?
Well, no, I just want to actually jump in and actually talk to Mayor Alsbury and see if he has anything regarding compliance on the local level that he'd like to also talk about.
It's just about similar to what he presented. I mean, we mirror a lot of what we require for local. I mean, we do a lot of the inspections ourselves, especially when we get complaints. So it actually mirrors exactly what he presented a few minutes ago. So thank you with that, Richard. So that worked out great.
Thank you so much.
Good.
Well, in the interest of time, I'm going to continue to go, and we're going to have Richard speak to the
Nicole?
legal process. Yes, sir.
We should probably ask Norm about his experiences as well.
Oh, that's a good idea. Norm, if you would like to offer some insight into your experiences with compliance checks, that'd be great. If not, that's okay as well.
No, it's important that that the retailers understand all that was conveyed and follow such guidelines. I'm not sure. I can't add much to
That's
that.
fine. That's perfect. Thank you very much, Norm.
Well said, yeah.
All right, we're going to go ahead and get to the legal process with Richard Haymaker. Thank you, Richard, for joining us.
Thank you, Nicole. A good afternoon again. As you just witnessed through Investigator Martinez's thorough presentation, there are a lot of things out there, a lot of possible pitfalls that a license holder can fall into and just simply trying to operate your business. To explain the legal process from there, it's pretty simple. But before I do that, I just want to tell you the reasons why the legal division prosecutes those cases, and also the reasons why we do events like this to help you educate. So first and foremost, we want to educate the license holders on all the possibilities of how to conduct a legally authorized licensed business. We don't necessarily prosecute cases to be penalizing, but we want to be able to, number one, educate, and sometimes the education will include having to issue a fine for the violation that the enforcement division finds during their inspection. The other reasons we do it is because we want to ensure, to the extent possible, that ensure an equal playing field. So if you follow the rules, if you follow the laws, and maybe your competitor does not, we want to be sure that everybody is playing by the same rules. So with that, there are three possibilities that can result from a violation found by the Enforcement Division. First is something called an offer and compromise. And an offer and compromise is something that is, in many cases, automatically sent to you based on what the investigator found. And it's one of those situations that if you are offered an offer and compromise, it's what's called an administrative penalty or an administrative fine. And generally, it's the lowest level of fines that the legal division will institute. And it's done so again to kind of create this environment of compliance. So an investigator can tell you, hey, you got to do this, this, and that. But sometimes if you have to pay a fine, that helps you remember. Let's face it, the reality is it. And other times, depending on the situation, the legal division may issue a formal warning. So that's kind of the lowest level of those administrative penalties. It's called an offer and compromise, and you would receive this in the mail or online, and you can choose to pay the administrative penalty through your MyTax account. So you never even have to interact with us here at the commission, with a lawyer at the commission, if you choose to pay that fine. If you miss the deadline in paying the fine, you will receive another notice. If you miss that deadline, then if you don't pay it before your next renewal, your renewal will be at risk of your license would be at risk of not being renewed. There's another option if you don't want to pay the administrative penalty, and that's called the pre-disciplinary conference. You can ask for, it's kind of like a pre-hearing or something we call a pre-disciplinary conference. So if you don't agree with the violation that was assessed during the inspection, you can choose to speak with one of the attorneys here, most likely Avi Zissuk, and you will meet with the attorney and go over the reasons why you think you don't deserve to be penalized. That's the second option. The third option is typically reserved for a more serious cases where we think there's more intent, maybe some cases involving other tiers, the relationship between a manufacturer and a distributor. I noticed there's a lot of distributors on the call, or the distributor's responsibilities toward the retailers. Depending on those situations, there is an option for the commission to send out what we call as a complaint and notice of hearing for there to be an administrative hearing before an administrative law judge. We haven't done that as much in the past, but because the commission has retained an administrative law judge over the past year, it's quite possible you'll see more of those cases in the future. But again, they're reserved for more serious cases, maybe some repeated offenses. In the serious cases might be, for instance, a second or third time sale of alcohol to a minor. Again, those are more serious cases. So we want to certainly avoid those. So that kind of closes out how the commission handles those violations that may be discovered by the Enforcement Division. Anything on that, Nicole, before we proceed to the appeals process?
No, actually, you can go ahead and go into the appeals process.
Okay.
Thank you, Rick.
So the appeals process is an interesting hat that the commission wears. As we've discovered through this presentation, the Liquor Control Commission, the State Liquor Control Commission, is a
Am I
regulatory.
confused or what? Hello?
I'm sorry? Okay. Uh, As I was saying, the State Liquor Control Commission is a regulatory agency. We issue state liquor licenses. But in Illinois, as you heard from Dushanka earlier, is a dual licensing state. So with that, there are local licenses that are issued in every single community, both incorporated and unincorporated throughout the entire state. So the Liquor Control Act, in addition to us issuing licenses and regulating our licenses, also gives us the responsibility of overseeing the issuance and regulation of local licenses. The Liquor Control Act requires us to serve as the primary or first appellate body for local liquor control commission decisions in every community across the state except the city of Chicago. What that means is we're the first appellate body, meaning the first body to hear the appeals of decisions of local commissioners. Either a liquor licensee or an applicant may appeal a decision of the local liquor control commissioner related to those licenses, those local licenses. Or in fact, any interested party can file an appeal. So it doesn't even have to be a licensee or an applicant. We have received a couple of those. In fact, one is pending right now where an interested party is appealing the issuance of a license. It's rare, but it happens. But most of the time, we hear cases involving local liquor control commissioners, revocations, suspensions, fines, refusals to renew, license denials. Those are the general cases we see. I'll get into the process. Just to give you a general overview of the entire process of filing an appeal. First, you would file the appeal, then you meaning any interested party, but most of the time it is a licensee. There is something called an automatic stay we'll get into and you can hold on, Curtis. I'm just going through the overview and then we'll get back to these in detail. We'll talk about the automatic stay. We'll talk about how we schedule status calls, how we conduct hearings, how the commissioners deliberate on a case, how we draft up an order, what happens after we draft up the order, something called the petition for rehearing, and also what happens after that. So there's a whole kind of rhythm to this appeals process, and if you've done it, then I think you understand it well. There's a lot of attorneys on this call who may have gone through that process, but if you're doing it for the first time, it obviously is going to be foreign to you. First, filing an appeal. I don't want to get too, I'll probably freewheel a little bit off the slides, but I'll try to stick to them to the extent possible. But I don't want to get too caught up in the nuts and bolts of filing the appeal. There are certain requirements that we mandate when filing an appeal. First and foremost is filing the actual notice. The notice of appeal you can find on our website. And it's not something that's overly technical that you might find that's required in a federal court somewhere. We're basically looking for either the licensee or the licensee's attorney or the interested party's attorney to fill out that form and file it with the commission. There are two things I think, in lieu of getting into everything you need to remember on this process, two things I think you need to understand. Number one, that for a notice of appeal, for an appeal to be valid, you have to file it within 20 days of the local liquor commissioner's action. So if that action was to revoke a license, it has to be filed with our office within 20 days of that action. If it was to deny an action, deny a license, has to be filed within 20 days of the denial of the license. So remember that first and foremost. Number two, I can't encourage you enough that if you're a license holder, especially an interested party, this is a legal process. So your chances improve exponentially if you hire a lawyer to represent you. I know it can be costly, I know it can be expensive sometimes, but trust me on this, it is something that, I mean, we do hear cases from license holders that represent themselves, but I think your chances of success increase significantly if you hire a lawyer to help you out with that. Go ahead to the next slide, Curtis. So when we receive appeals, they can either be received through the mail or they can be filed through our web address at ilcc.legal@illinois.gov, or they can be mailed to our address. Most of the time we do receive them through our web address, our email address. But what that does, if you can go to the next slide, Curtis. Yes, as soon as the appeal is filed, something happens that you don't see very often in other areas of the law. So if an appeal to, let's say, a revocation decision, so a local liquor control commissioner has revoked a license, and the license holder files the notice of appeal with us within 20 days of that decision, then by the operation of law, the license holder may continue to sell alcohol as long as the appeal to that matter is pending with our commission. So that's one thing to understand about something we refer to as the automatic stay. When we receive a notice of appeal, we'll send a letter out to both parties, both the local commissioner and usually the license holder. When that notification letter is important because it notifies both sides that the automatic stay, in most cases, and I'll get to the exception in a second here, in most cases is in place. There is the exception. If the revocation, or let's say it's a suspension, let's say it's a 5-day suspension, is the second revocation or suspension that the local commissioner instituted or imposed within the last 12 months. So if it's the second revocation or the second suspension within the last 12 months, then there is no automatic stay provision. What we will do in those situations, and also we will do in license application denials, to the extent that we can, we will expedite those cases because we know that either the license holder is closed, or at least they're not selling alcohol during this appeal process, or they're waiting to receive a license in the case of a license denial. Just as a note, this entire process that I'm going through right now only pertains to the local liquor license and how a local liquor license is appealed. It is not relevant, or it does not pertain to the local business license. A lot of municipalities will issue a local business license to authorize that business to sell other items, including alcohol. And it's just to make you aware that a lot of times, at the same time an appeal is filed on a liquor license, another appeal is pending on the business license. That appeal is not pending with us. It's an appeal that is pending before the circuit courts. So just wanted to make you aware of that. A lot of times those get those two licenses get conflated. We only have jurisdiction over the liquor license. Next slide, Curtis, I think is the status call slide. So we try to keep the process as moving along. We don't want appeals to sit for very long because either the licensee's interests or the local municipality's interests, in fact, both interests are in play on these issues. And we understand how important they are, obviously, to the business and to the local commission. So within, once we receive the notice of appeal, we will schedule a status call for the first Friday of the next month. So if we received an appeal today, we'll try. Today's October 30th. We have a status call this Friday on November 1st. We would do what we could to get that on the call to the extent that schedules would allow. But certainly if one was filed, let's say October 15th, you can be sure that we would hear that status on November 1st. And the status call is not the formal hearing, just to be clear. What it is simply a meeting between the commission, which it includes the commission staff, and also the chair of the License Commission, Chair Byrd, and also the parties. So both the licensee and usually the attorney for the local commission is included in the status call. And a number of others will also be on the call. And when I say call, I mean video conference call. Like, that's one thing I suppose COVID ended up having a positive influence over, because now instead of bringing the lawyers down for hey, where are we at in this case discussion, which would obviously increase the costs both to the locals and to the licensees, we basically have no more than for each case, 5 at the most 10-minute discussion about where we're at with the case. And this is all on video, over a video conference call. In most cases, what we also discuss at the status call is the local commission will have to file the record of the local hearing. So in most of our cases, a revocation case, a suspension case, the local commission will have had their own hearing by the time that we get the case. So what we discuss at the conference, at the status call is, okay, when was the hearing held? What happened at the hearing? Do you have a transcript for that hearing? The Act requires local commissioners that hold local liquor hearings over local liquor licenses for you to have a hearing, and also for it to be transcribed verbatim, word for word, a hearing be transcribed by a certified court reporter. So for all the local commissions out there that, I just want to emphasize, it's important to get a certified court reporter for your hearings. If you're doing it through audio recording, we'll try to make that work, but I wouldn't, because the licensee can raise that as an issue, and we've seen it raised as an issue as not as the local not following the black letter of the statute by getting a certified court reporter for their hearings. So that's an important piece of the local hearing. In addition, though, that once we get the case on the appeal, we are going to need a copy of that transcript and also all the other documents which constitute the local record. The statute requires the licensee pay for the transcription services. So a lot of times a court reporter goes to a hearing, takes down the verbatim record of the hearing, but they don't actually transcribe it until they're asked to. Well, in this case, if they are asked to transcribe it, it's an additional cost. The statute requires the person filing the appeal to pay for that transcript. Once they pay for that transcript, the local commissioner can receive the transcript, and then they can file it with our commission along with the rest of the record. So that's something that we discuss in the status call. Where are we at with the transcript? Go ahead, Curtis. We'll pass through this. It's just when somebody files files a notice of appeal, their counsels have to file something called appearance forms, which let us know who's the formal representative for either the local commission or the licensee. And also we ask them to file some other notices, but we'll walk each party through that when an appeal is filed. Next slide. When we monitor the case by again determining these transcripts and the certifications, and we only schedule a formal hearing once we have received all of the documents that we need to proceed, and typically those are going to be the notices of hearing that the locals sent to the licensee when they held their hearing, the transcript, as I've discussed, the order that the local commission drafted to either revoke or suspend or fine or deny the license, and then some supporting documentation that go along with that, like some of the evidence that was introduced at the hearing, and also maybe some of the ordinances that the local commissioner relied on to make their decision. Next slide, Curtis. Once we have all of those documents, we're ready for the hearing. We will send a formal notice of hearing out for the time and the place for the hearing. Now, I'll kind of again, as the slide suggests, we'll talk a little bit about the differences between two possible types of hearings. The vast majority of our hearings are what is called on-the-record hearings. If it's an on-the-record hearing, personally, I think that's good news for both sides. You can disagree with me. That's kind of my personal opinion. But the reason I think that's good news for both sides is because if it's on the record, first of all, it means that the local municipality has passed an ordinance that says that the review or the appeal of all of the decisions of the local commissioners must be heard on the record. It means that the state commission, when we rehear the case, we're not taking in any new evidence. We're only evaluating the hearing process and the evidence that was introduced at the local commission hearing. That's good news for the licensee, I think, because that means it's a much more streamlined appeal. It doesn't have to be as many costs associated with your appellate rights than need to be, as with the other type of case, which I'll get into in a second. So the cost will be much lower if it's an on-the-record case. The reason it's, I think, good news for the local commissioner is that it's means that the local commissioner doesn't have to prosecute the case and prove the case all over again. So picture this, there's a hearing that is held on, let's say, October 1st. The decision comes down October 31st, revoking the license. Let's say the hearing process was a week for an administrative hearing, and the local commissioner introduced evidence and had witnesses and the whole thing. It's like a regular trial. Then they file, the license is revoked, and the licensee files an appeal. Well, if it's a de novo, if it's not an on-the-record case, then the whole thing has to start over again. Once it gets to us and the licensee files an appeal, we have to do effectively another trial from start to finish, just to hear the appeal. So again, most of our cases are on the record. If they're on the record, we will do them through video conferencing, because it's a simple, 45-minute to an hour hearing where both sides make their legal arguments, and we're done. We're done with the hearing, usually in less than an hour, as opposed to multiple days. De novo hearings, they're rare, but they do happen. And usually we can conduct a de novo hearing, which again is like a trial from the beginning to an end. We can conduct that through video conferencing, but in many cases we don't, because it just becomes too complicated. The logistics become too complicated with hearing evidence from witnesses, and if somebody has background noise, it's difficult to figure out what they're saying. So that can go either way. So that's the fundamental, that's what a hearing could look like. At each of our hearings, we'll have 2 of our commissioners preside over the hearings. There'll be a representative of the legal division who will there to make legal decisions, but it'll be the commissioners presiding. In most cases, the licensee will make their legal argument, the local commissioner will make their legal argument. There'll be some time for rebuttal, some time for commissioner questions, and then we'll conclude the hearing. Next slide. This is something called the pre-hearing memoranda. It's one of those documents that we would require before having the hearing. Really, it's just a big phrase for summarize your case in writing. Unlike matters in the circuit court, it's not like a briefing schedule where one of the sides will file a brief, and then the other side will have 30 days to file a response, and then the other side will have 15 days to file a reply to the response. We ask that the pre-hearing memoranda be filed concurrently together, or at least on the same day, approximately 14 days before the actual hearing, to give us a chance to review the summary of the legal arguments. There are times in de novo cases where, yes, we will decide pre-hearing motions, and in some cases that will involve a more formal briefing schedule. Next slide. So when the hearing is completed, the staff will, in 99.5% of the cases, will prepare, well, I'm sorry, in all the cases, the staff will prepare the record. Sometimes the record is a result of a de novo case, which will include certain items and evidence. But most of the time, it's going to contain the administrative record that was created at the local level, and also the hearing transcript from the state hearing. It's all prepared and sent to the commissioners, all 7 commissioners, so not 2, but all 7 commissioners, for their review before the next commission monthly meeting. What happens at the meeting is they will have reviewed the record of the case. The staff makes a brief presentation about the issues of the case, and the commission deliberates on what the decision is going to be. Now, this is all done in something we called closed session. It's not open to the public because there is an exception to the Open Meetings Act that allows the commission to deliberate on these matters where there was an open hearing. The commission can deliberate on these matters in a closed session, but they will make a decision, and the decision will be one of three things. They will either affirm the decision of the local commissioner, which could be to revoke or to deny or suspend a license. They will reverse the decision of the local commissioner, or they will modify the penalty that the local commissioner instituted or imposed. For instance, if the local commissioner imposes a revocation, the state commission could impose instead a 30-day suspension of the license. The commission does not like to do that. It only does that in rare situations, but it can happen because those three options are what's required by the Liquor Control Act. And just kind of a side note, the commissioners make the call as they, in most cases, agree what that call will be, but in some cases they disagree. But whatever the case, they're making the call. The majority of the commission will make the decision. Legal staff will have input, but it's their call. Next slide. Once the commission makes the call, the staff will be directed to draft an order. It's kind of a formal basis for the commission's decision. Hopefully that's done within 30 days of the commission's decision, and the staff will then send that out to both parties, both the local commission and the licensee. From that date of the commission order, either side, and I suppose in theory sometimes in the case of a modification, both sides could file a petition for rehearing. It's basically, hey, usually it's the losing side, the side that didn't get what they wanted. Hey, are you sure? Here's a reason why you might have made an error in your decision. Whatever the case, that petition for rehearing, again, has to meet a deadline, has to be filed within 20 days of the date of our order. Not necessarily the date of the commission's decision, but the date that the commission staff drafts, formally sends out the order to the parties. So that's an important deadline because even if the commission doesn't grant the petition for rehearing, and quite frankly, I've never known the commission to grant a petition for rehearing, it's important to do that to preserve any rights that you might have at the next level. And those rights include filing an appeal at the circuit court. So in the relevant county of whatever jurisdiction you're in, you could file a complaint for administrative review in the circuit court, and then it could be appealed to the appellate court, and then could even be appealed to the Supreme Court. So again, these are very legal proceedings, and again, I recommend you hiring a lawyer to help you out with that. One thing, if the commission denies the petition for rehearing, we'll then bring it if the commission receives a petition for rehearing, we'll bring it before the commissioners at their next monthly meeting. Commissioners, if they deny it, we'll send out an order. The staff will send out an order, and from that date, the licensee or the Liquor Control Commission, in case of a reversal, has a right to file for administrative review within 35 days of the denial of the petition for rehearing. So again, those deadlines are important. The circuit court usually doesn't give an ounce on those deadlines. If the deadline is 35 days or if the deadline is 20 days, it means 20 days. And those are calendar days. I don't think it's business days or anything like that. Those are calendar days. So don't blow those deadlines on either side. Okay, so I think I've exhausted the appeals process from beginning to end, and I'm happy to take any questions if anyone has any.
Thank you, Rich. I appreciate all the information that you provided to us. I will go ahead and start asking some questions that were pre-submitted to us. And I'm going to start with licensing first. And some of these questions are for all of you, some are for specific individuals. And I want to start off with this question, particularly for Norman. As a license holder, what has been your experience with the license application process?
Well, actually, my experience has been that if I paid attention to the application and I read it thoroughly and answered all of the questions correctly and provided the requested information, the application process is fairly seamless. Only if you follow the direction.
Okay. And how has your experience with it? I know at some point we had applications where we have to come into the office and fill out, but now that there's an online process, do you find that to be a lot more streamlined and user-friendly?
Very, very much so. Not only is the application process streamlined, but the renewal is even better.
Okay. All right, thank you. I have another question that for Deshanka, Mayor Osbury, and you, if you'd like to answer. What are some of the common issues with the application process that delays or prevents a successful application? And are there any ways or tips to avoid issues? I'll start with Deshanka.
Thank you, Nicole. And just to kind of follow up with what Norman said earlier, one thing is it's so important, and Norman has contacted our office before. If you do have questions, or if you need assistance, please feel free to reach out to us. You can reach out to us via phone, or you can reach out to us via our inbox, ilcc.licensing@illinois.gov. So please reach out if you have any questions or concerns. In reference to some of the issues or some of the delays, I would definitely make sure to remind all of our licensees, try to get your license renewals to us as soon as possible. We try to send these out 6 weeks in advance. You're sent reminders to renew your license 6 weeks prior to your expiration date. So make sure to try to get those to us as soon as possible. Also, one of the issues we've had is if a licensee submits it, today's the 30th. Tomorrow we have quite a few licenses expiring. So if you submit it today and you try to submit it today and you notice you have a tax hold on your account, well, you only have a couple of days to try to get the issue resolved. So that's an example of when we would, like you to send, make sure you apply timely, just in case you run into tax hold issues. Another issue is if you send us a copy of your policy declarations and not your certificate of insurance. We definitely need a copy of your official certificate of insurance. And also if you send us a copy, and sometimes it's just an oversight, some of our licensees will send a copy of their state of Illinois liquor license as an attachment for their renewal instead of the actual local liquor license. So keep that in mind as well.
Mayor Osbury?
One of the things we find is they'll file with someone who has some issues with their background, and they'll put them on a license and they end up kicking back because they have some history of one issue or another. That slows the process down. A lot of times some people put the wrong address on their application. Those are just some simple things that usually happens locally. before we find out.
All right, thank you for that. Another question is, the state and the local may have different license renewals. So on the state level, Deshanka, what is the renewal timeframe? And then Mayor Osberry, I will ask you the same question next.
Sure, sure. So what I've seen on the local level, I've seen a lot of local municipalities will have all their licenses expire at the same time, maybe the end of the month in April, June, or the end of the year. For the State of Illinois Liquor Control Commission, when you are issued your first initial liquor license for that premise location, you are issued an expiration date, and that expiration date follows you through your whole license history. And how we determine the expiration date is based on the issue date of the local license. So let's say Mayor Ellsbury's office issues you a local liquor license with an issue date of October 30th. It's a new license. This means your State of Illinois liquor license will expire September 30th of the following year. What we do is we go a month prior to when the local license was issued, and then it's the following year. So for this example, if the license is issued on October 30th, the State of Illinois liquor license would expire September 30th. Of 2025, and that date will follow you through your license history.
Okay, sound pretty accurate, Mayor Osberry?
Yes. I was basically, I'm gonna read it because it's kind of long. It said, our license terminated on the 13th day of April, next following issuance. So every 13th of April, you have to file for your license or renewal. And we prorate those. So if it comes, it's only a half a year, you only pay a portion of what your license is, maybe. And if not, if it's a whole cycle, then you pay the full amount.
Okay.
So that's how it's basically determined.
Okay, thank you. Another question, this is for Norman, actually. What would you consider to be the top 3 challenges for anyone trying to become a retailer?
Challenges in trying to become a retailer. Again, the biggest, I guess, challenge is understanding the application process. Well, I'll back up. First, I think just being able to assure that the space in which you're trying to occupy do in fact meet the criteria for a liquor license. That's one. And then again, understanding the application itself, because it's very specific. And if you follow those guidelines, I don't think you should have any issues. But again, just understanding the eligibility, because again, everyone can't hold a liquor license, so you have to assure, as the mayor spoke, to assure that your background is in order, as well as anyone who you're partnering with. I think those are the biggest challenges. You get through those pieces, it should be easy sailing post that.
Okay, perfect, thank you. I have a question for Mayor Osberry. This is regarding zoning. What are some of the zoning requirements for obtaining a liquor license in your township?
Ours is pretty basic. As long as it's in a business district, will allow you to have a liquor license. Anywhere where we have a business district, so it doesn't matter closeness or anything like that per se, because mostly all our business districts are located away from schools and things like that. So just as long as you're in a B1 or B2 business district.
Okay, thank you. That you actually answered my follow-up question, so thanks for that. One question I have for Deshanka. Excuse me. Can you sell alcohol while an application is pending?
So it's a very good question. We get this question a lot. So let's say the local liquor license has been issued, because in order for you to apply for a State of Illinois liquor license, one of the prerequisites is that you have that you attach a copy of your local liquor license. So some licensees or applicants may think, well, I have my local liquor license, I can begin selling alcohol. And the answer to that is no. Illinois is a dual license state. You must have a valid local liquor license and a valid state of Illinois liquor license. So you need both.
Okay. All right. I'm gonna ask this question for state and local. Are there any trainings, courses that people have to take when they become as they try to become a licensee? Nothing? Okay.
Hold on.
Yeah, I can just chime in on that. I don't
Okay.
know of any particular trainings that one has for operating as a licensee, but I do tell you this. When we have posted that first inspection checklist specifically for this reason, so this way retailers have an opportunity to view what their potential first inspection or subsequent inspections will be like. So that is a good resource to look at. It is a good educational tool. When our agents are at a location, we always try to educate our retailers on anything they're doing or anything that's with a potential violation, or even when they have a violation, of why it happened, what the relationship is with what they did and what is out of compliance. So we're always in that educational mode as much as we can be, and as much as the reception we get for that particular delivery of that message. So I wanted to say that about that education.
Yeah, and remember, most of the license holders themselves may not be formally required to have any certificates, at least for liquor, probably for food and things like that. But their servers do. If you're a server at a restaurant or a bar, or if you're checking identification at a bar, then you are required to have that Bassett certification. And that is something that the enforcement division looks at very closely.
Thank you for
And Nicole, that inspection checklist, it prints out with the license certificate. So every time you renew your license, that checklist is included. So it's a constant reminder for our licensees.
All right. Perfect. Thank you. Next question is for Deshanka. Can you apply for a one-day liquor license if you do not have a 1A retailer's license?
So a one-day liquor license, earlier in my slides, I went over the special event, not-for-profit liquor license, which does not require that you have a 1A retailer's license. So you could be a church, for example, or not-for-profit organization, and you can apply for a one-day license, special event license. We also have a special use permit, and those are issued for special events. For retailers, those are our 1A retailers. They qualify for special use permit. And there are some in the manufacturing tier as well. Our brew pubs, our distilling pubs, and our winemaker retailers that qualify for a special use permit. What happens in a scenario when you're not a special event not-for-profit organization, you're not a 1A retailer or a manufacturer in one of the license classes that I just referenced? There is a one-day for-profit liquor license that you may qualify for, but you need local approval. So this license is a $750 license, and you must get approval from the local municipalities. What we've seen is a lot of local jurisdictions, they don't have this license type. They cannot grant approval for this license type. In their ordinance, it's very specific. They can only issue to a registered not-for-profit organization or a retailer that can apply for a special use permit. So the answer is yes, there is that option, but once again, you must get approval from the local municipalities. And if they don't have this license type, then you're not going to be able to get that license with us as well.
Okay. Mayor Osbury, you agree with that?
Yes, we do one-day event licenses for special events locally, and so we have, like I said, we have 12 different licenses that cost different amounts of money, and we cover just about everything from event spaces to something that a local business wants to do on a special day. Some bars have certain hours they can sell alcohol. They may want to do a special event within their facility, and we issue that license also, which is a one-day license. It's basically a one-day early opening license or late closing license.
Okay, thank you for that. The last question, well, one of the last questions, for Deshanka. Can a self-distributing brewery sell packaged liquor off-site at events like a farmer's market?
So I just referenced in the manufacturing tier, we have a small group of licensees that may qualify for a special use permit. And that would be a brew pub. The license prefix is 1C as in Charlie, a distilling pub, 1X, or a winemaker premises. License prefix is a 1E. The problem is, with this question, it references off-premise sales, and the statute does reference that these types of licenses, special event licenses, are for on-premise sales.
Okay, thank you for that.
And
All right.
also, if I could just clarify, Deshanka, the license you referred to, brew pub and winemaker premises and distilling pub, those we classify as retailers with limited manufacturing privileges, right?
Yes, correct.
In general, if you are a brewer, winery, or a distiller, you would not be authorized to conduct special uses off premises. Even though some of these businesses may sell their own alcohol at retail.
Okay, thank you. All right, moving on. I have a question for Mayor Osbury. Are there legal hours for selling alcohol in your township? What is the cutoff time?
Yes, our cutoff time is 1 a.m.
1 a.m. Thank you for that. And we don't have anything for the state in regards to that, correct?
Yes, correct. We leave it to the local communities to govern hours of operation.
Okay. And this is another question. It's come up again. I think Rich, you actually, or George probably spoke on it. Can a retailer promote a contest and give away alcohol as a prize?
Absolutely not.
Great.
No.
Perfect. Easy response. So that is a no. Next question. What should I do if I'm issued a violation?
Yeah, I could probably get into that. I touched on it before. So the investigator, the inspector, liquor control agent is out. They've conducted their inspection. They've checked a few boxes where it seems that the license has committed one or two or maybe more violations. As soon as that happens, those alleged violations are entered into the license system. They're reviewed by the license supervisor. So only then does it become a more formal violation. When the supervisor signs off on it, the licensee will likely, I'd say in about 90% of the situations, will get the what I referred to earlier as an offer in compromise sent to them, either in the mail or through their email or through MyTax. Once they receive that offer in compromise, they should know that it's an administrative fine. Basically, to serve as one of these reminders to them of what they need to do to run a compliant licensed business. From there, they have two options. And one of the third option I don't recommend, but the one of the two is to either pay the fine, which can be paid online, or to schedule what's called a pre-disciplinary conference, which can be scheduled through our website to meet with an attorney here at the commission to discuss the consequences of the alleged violation. The third thing I don't recommend is to just ignore it, because that will put your license renewal in jeopardy if it's ignored.
Okay, thank you. Next question. What happens in the event that a license holder passes away? And what steps should a business partner, spouse, or family member take to have the license transferred?
That's a tough question. Again, it's probably more in
Well,
line. Go ahead, Mayor, if you have an answer.
Well, basically, they have to go through the process over again. License is attached to the person. And so it's not attached to the business. So they would have to actually reapply again with a person holding that license.
Okay, thank you for that. All right. If someone buys a business with an existing license, does that license transfer to the new owner?
Same answer.
Same answer. All right.
There are two types of applications at the state, and each municipal community is different. So again, reach out to your municipal community to see what those rules are. But there are two types of applications that can be submitted if a business is bought and sold. One is called a change of officers application, which means that new ownership are coming on to the existing license. Which means, just as a quick example, if ABC Inc. is owned by Jane Smith and Jane Smith sells it to Bob Jones, then Bob Jones has to file a change of officers application for ABC Inc.'s license. If, however, the ABC Inc. is not being transferred, that XYZ, that Bob Jones is forming their new entity, new corporation, new limited liability company, they absolutely would have to file a new license application in that situation. Now, even in the first case I mentioned, it's possible the local commission will still have them go through the new application process.
Okay. All right. This question is for George. If a special or Deshanka, if a special event runs out of alcohol, can they go to a local retailer and purchase more alcohol to sell?
I'll give it a shot. So that is usually no, but yes. So, and I'll tell you yes. So, but you'd have to read the 5/5-1, which gives you the option to purchase alcohol if it's no more than $500. So I can read it to you real quick. Unless the licensee purchases less than $500 of alcoholic liquors for the special event, and that's not a special use, that's special event. In which case, the licensee may purchase the alcoholic liquors from a licensed retailer and shall allow them to sell it and offer it for sale at their designated event. Cannot be more than $500.
Okay. Thank you very much. Last couple questions because we are about 8 minutes out. When should someone file an appeal? I believe that'd be for Rick. You're on mute.
Okay, absolutely no later than 20 days from the date of the decision of the local liquor control commissioner. So just remember that 20 days, and those are 20 calendar days.
Okay. Now, is there any specific information that a person needs to provide, will include in their appeal?
At the beginning, all they need is to fill out the notice of appeal that's on our website, the Illinois Liquor Control Commission website, and fill out the who they are, the basis for their appeal. Ideally, they'd find legal counsel as well. But if they file that with us, they follow the directions on the notice of appeal, filing the appeal at ilcc.legal@illinois.gov. We will consider the appeal filed, and then we'll work on, after that, what other documents need to be filed to get us to that hearing.
Okay. Another question is, can I continue to operate or sell liquor while the appeal is pending?
Right, so if, let's say the local commissioner revokes the license, then once the notice of appeal is filed with our commission, and we send that acceptance letter, it notifies all parties that the revocation or the suspension is stayed, meaning that it is not in effect while the appeal is pending. So again, the exception to this is if it's a second revocation or second suspension within a 12-month period, then they must cease selling alcohol while the appeal is pending. And we will do what we can to expedite that, that case. There's one other thing on that, is that a person may continue to sell alcohol, presuming it's not a second revocation within 12 months. They'll continue to sell alcohol while the appeal is pending, and that includes the point at which the petition for rehearing process is in place. So if the commission affirms or agrees, if the state commission agrees with the local commissioner that the business license, that the liquor license should be revoked, and we send an order out, and then the licensee files a petition for rehearing, the stay is still in place until the commission, the state commission, makes a final ruling on the petition for rehearing. That only after that last part, either the 20 days expires where a petition for rehearing can't be filed, or the decision on the petition for rehearing, the business can continue and sell alcohol while the appeal is pending.
Okay. All right. One more question. On the state and local level, how can someone report a licensee of selling to underage minors or just selling illegally?
I'll answer that with you can report it, either go to our website and go to the enforcement tab, and there you can find a complaint section where you can file, and I say you can file anonymously, a complaint or a tip against any licensed entity in Illinois. And you can remain anonymous, but I tell you, it's best to leave information so we can then review what information was provided and then get some more details. But I assure you, it's a safe place if you want to report something, and you can remain anonymous if you wish to.
All right, thank you. Well, I am going to wrap up the questions for now. We are done with those. And I want to thank everyone for being a panelist today. It is very much appreciated. And I know that people got a wealth of information from you all. Right here on the screen, you'll see the contact information for all of the divisions. If you have any questions, please go ahead and email them to our respective divisions, and we do a great job of responding. I want to thank Mayor Osbury and Norman for joining us today. We really appreciate you guys being on and giving some insight to your areas of expertise. Again, thank you to Shanka, Rick, George, and Director Gardner for jumping on and speaking to us all today. And that will complete this webinar. Have a wonderful day, and you can find this webinar on our YouTube page momentarily. Thank you all again, and have a great day.